What do we know about guns? Well, if you've gone to buy a gun ever in my lifetime, you had to fill out a background check form. And on that background check form is a line that says, I am not an unlawful and habitual user of marijuana. Something like that. Well, our protagonist today, Patrick Darnell Daniels Jr., got arrested for being both a marijuana smoker and a gun possessor. Nothing more. The man is not otherwise like some massive criminal that needed to be taken off the streets. This is kind of a good case so far, as far as I read. We'll see the details in a moment. And so the Fifth Circuit Court of Appeals has ruled that marijuana is not a sufficient reason. Just a history of use of marijuana is not a sufficient reason to preclude someone from firearms ownership. There are limits, and we'll get to those. It's the same kind of limits you would put on any kind of intoxication and firearms. So you can't be high and shooting or carrying, but you can be a user, and then when you are sober, you can also be a carrier or owner of the firearm otherwise. So this is the United States Court of Appeals for the Fifth Circuit, and this is before Judges Smith, Higginson, and Willett. Title 18 U.S.C. Section 922 G3 bars an individual from possessing a firearm if he is an unlawful user of a controlled substance. Patrick Daniels is one such unlawful user. He admitted to smoking marijuana multiple days per month. I do not know why marijuana is spelled with an H. Maybe someone can tell me why you choose an H versus a J. Is it an Americanization of the word? Is it interchangeable? I don't know. But the government presented no evidence that Daniels was intoxicated at the time of his arrest, nor did it identify when he last had used marijuana. Still, based on his confession to regular usage, a jury convicted Daniels of violating the law. The question is whether Daniels's conviction violates his right to bear arms. The answer depends on whether 922G3 is consistent with our nation's historical tradition of firearms regulation. See the New York State Rifle and Pistol Association v. Bruin case from 2022. It is a close and deeply challenging question. Throughout American history, laws have regulated the combination of guns and intoxicating substances, but at no point in the 18th or 19th century did the government disarm individuals who used drugs or alcohol at one time from possessing guns at another. A few states banned carrying a weapon while actively under the influence, but those statutes did not emerge until well after the Civil War. Section 922G3, the first federal law of its kind, was not enacted until 1968, nearly 2 centuries after the Second Amendment was adopted. In short, our history and tradition may support some limits on an intoxicated person's right to carry a weapon, but it does not justify disarming a sober citizen based exclusively on past drug usage. Nor do more generalized traditions of disarming dangerous persons support this restriction on nonviolent drug users. As applied to Daniels, then, 922G3 violates the Second Amendment. We reverse the judgment of conviction and render a dismissal of his indictment. In April of 2022, 2 law enforcement officers pulled Daniels over for driving without a license plate. One of the officers, an agent with the Drug Enforcement Administration, DEA, approached the vehicle and recognized the smell of marijuana. He searched the cabin and found several marijuana cigarette butts in the ashtray. In addition to the drugs, the officers found 2 loaded firearms, a 9mm pistol and a semi-automatic rifle. Daniels was taken into custody and transported to the local DEA office. I do have an issue with him smoking and driving at the same time. That's not allowed. Smoking and having the firearms, that's probably also not good in my book. But I think you're going to see the judge and the case is limited to simple possession of the firearms and a history of marijuana, because the government didn't present any evidence of current usage or current intoxication. Was he actively intoxicated when he was arrested with the guns and driving? That's bad, but they didn't. That isn't the case they brought or made. At no point that night did the DEA administer a drug test or ask Daniels whether he was under the influence, nor did the officers note or testify that he appeared intoxicated. But after Daniels was Mirandized at the station, he admitted that he had smoked marijuana since high school and was a regular user. When asked how often he smoked, he confirmed he used marijuana approximately 14 days out of a month. Based on his admission, Daniels was charged with violating 922G3, which makes it illegal, as we said, for any person who is an unlawful user of any controlled substance to possess any firearm. An unlawful user is someone who uses illegal drugs regularly and in some temporal proximity to the gun possession. While Daniels was under indictment, the Supreme Court decided Bruen. It clarified that firearms regulations are unconstitutional unless they are firmly rooted in our nation's history and tradition of gun regulation. This is the originalist argument. We've gone over this before. The new constituency, the new constitution, but I don't want to say constitution because that's a legal word. The new makeup of the Supreme Court seems to be in favor of constitutional originalism, which means if it wasn't in the original Constitution as it was written 250 years ago, it doesn't count. So we didn't have this same level of firearms regulation then as we do now, so we have to now undo firearms regulation to go back to 1789 or whenever it was enacted and codified and ratified. Daniels immediately moved to dismiss the indictment under Bruen, claiming that 922G3 is unconstitutional under that new standard. The district court denied the motion. It expressed doubts that Daniels was part of the people, whom the Second Amendment protects, as Daniels was not a law-abiding, responsible citizen. So only law-abiding, responsible citizens in that judge's eyes. Southern District of Mississippi, 2022? Yeah. That judge's eyes, in that judge's eyes, Daniels was not the people because he was not a law. So if you make anything illegal, then he's not a law-abiding citizen, then he can be excluded from rights. That's what that judge was saying, and that's completely wrong. Nevertheless, assuming that Daniels had a right to bear arms, the court found that 922G3 was a long-standing gun regulation. It compared the law to laws disarming felons and the mentally ill that Heller called presumptively lawful. That's the District of Columbia v. Heller case from 2008. Congress passed 922G3 in 1968 only after many states had similarly banned habitual drug users from possessing guns. The district court placed great weight on that regulatory tradition. It engaged with few historical sources from the founding or Reconstruction, but it relied on statements from other courts, notably all predating Bruen, that 922G3 was supported by the historical practice of disarming those who exhibit a dangerous lack of self-control. Marijuana users exhibit a dangerous lack of self-control, according to this judge. Like, can you have a marijuana user who also exhibits a dangerous lack of self-control? Sure, but you can also have a sober person who exhibits a dangerous lack of self-control. Putting the marijuana user in the same category as exhibiting a dangerous lack of self-control is a false equivalency. You're saying that because somebody does something dangerous and they also do this totally benign thing, that they must be connected in some way, and they're generally not. A jury found Daniels guilty. He was sentenced to nearly 4 years in prison and 3 years of supervised release. 7 years of state supervision total, 4 in custody and 4 in release, for simply having a firearm and having a history of marijuana use. This is the injustice of it all. This is the unfairness of it all. People who commit far worse crimes don't go to jail, and then this kind of thing. This guy's going to go to prison for, well, I don't know if he actually made it to prison, but 4 years and 3 years of supervised release. Unbelievable. Daniels is also barred for life from possessing a firearm. He appeals his conviction, reasserting the Second Amendment challenge that he raised before trial. As with all constitutional questions, we consider the issue brand new. So the court is going to start from the beginning. The Second Amendment protects the right of individuals to keep and bear firearms for their self-defense, but even fundamental rights have limits. Before Bruen, our circuit evaluated the legality of gun restrictions using the familiar standards of scrutiny, strict scrutiny, intermediate scrutiny, or rational basis scrutiny, the lightest version. If legislation infringed on the historical right to bear arms, we asked whether the government had a sufficiently strong interest and whether its firearm regulation was sufficiently tailored, that's intermediate scrutiny. If a law breached the core of the Second Amendment liberty, we then applied strict scrutiny, where the restriction must be narrowly tailored to achieve a compelling government interest. Bruin decisively rejected that kind of analysis. In place of the means-end balancing, Bruin requires us to interpret the Second Amendment in light of its original public meaning. As this court explained, the Second Amendment codified a pre-existing right within pre-existing limits. To ascertain those limits, our history is our heuristic. Because historical gun regulations evince the kinds of limits that were well understood at the time the Second Amendment was ratified, like 1789, somewhere around then, a regulation that is inconsistent with those limits is inconsistent with the Second Amendment. So there is no adapting for modern times in the originalist argument. To determine whether a modern firearms law is unconstitutional, we now proceed in two steps. First, we ask whether the Second Amendment applies by its terms. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. Second, we ask whether a given gun restriction is consistent with the nation's historical tradition of firearm regulation. The government bears the burden of demonstrating a tradition supporting the challenged law. Only by showing that the law does not tread on the historical scope of the right can the government justify its regulation. So this is different than the scrutiny analysis. The second step requires both close attention to history and analogical reasoning. Bruin did not forswear all legislative innovation. To the contrary, the Constitution can and must apply to circumstances beyond those the founders specifically anticipated. What we are looking for is a tradition, well-accepted limits on the right to bear arms manifested by a tangible practice of comparable gun regulations. But how do we know whether an older regulatory practice is comparable? Bruin helpfully gives us two conceptual pathways. If the modern regulation addresses a general societal problem that has persisted since the 18th century, then the lack of a distinctly similar historical regulation addressing that problem is relevant evidence that the challenged regulation is inconsistent with the Second Amendment. If this sounds confusing to you, it is. Why in the world are we using 250-year-old law to decide how firearms are regulated? Firearms that are made with techniques in 2023. It's a different world. I think everyone would agree it's a different world, and I hate it, but this just seems like a logical detour, maybe an illogical detour, but it's a logical detour to try to get around the situation of we need to regulate these damn guns, but we don't want to take anybody's guns away, so we're just going to rely on, oh, well, we have to go back to the beginning of time, and, oh, well, we didn't have a regulation back then, so now we don't have a regulation now. It's oversimplified, and I think it's an end run around any attempts at regulation. But what are you going to do about it? There's no path to override the Supreme Court's decision that does not involve a constitutional amendment, basically. And I don't think we have any kind of agreement, any kind of uniform agreement on a constitutional amendment on gun regulations at this time. I'll put it that way. But if a modern law addresses unprecedented societal concerns or dramatic technological changes, it calls for a more nuanced approach. We must reason by analogy to determine whether older regulations are relevantly similar to the modern law. Bruin acknowledged the difficulty of determining whether two laws are relevantly similar. Bruin clarified that two laws are relevantly similar if they share a common why and how. They must both address a comparable problem, the why, and place the comparable burden on the rights holder, the how. Future legal scholars are going to look back at this Bruin decision and laugh. I mean, this is kids' kind of logic, like to try to think your way around it. Oh, well, if I make blue equal to orange, then I can do whatever I want. In all of that, Bruin reminded us that we are looking for a representative historical analog, not a historical twin. It is not a death knell to the government that the challenged regulation did not previously exist. What matters is whether a conceptual fit exists between the old law and the new. Deciding whether there is a match between historical and modern regulations requires the exercise of both analogical reasoning and sound judgment. Nevertheless, we hew closely to Bruin's own reasoning and hold the government to its heavy burden. And that's the problem now. Now Bruin is law, and even people who firmly disagree with its reasoning now have to try and make their case within its framework. It's frankly, legally, professionally ridiculous. And this comes from a person who is in favor of appropriate firearms regulation. I do not think that this Bruin decision is helping anything. Kind of like the Citizens United decision. We begin with the threshold question, whether the Second Amendment even applies to Daniels. The right to bear arms is held by the people. That phrase unambiguously refers to all members of the political community, not an unspecified subset. Indeed, the Bill of Rights uses the phrase the people 5 times. In each place, it refers to all members of our political community, not a special group of upright citizens. Based on that consistent usage, Heller concluded that the Second Amendment right is exercised individually and belongs to all Americans. Even as a marijuana user, Daniels is a member of our political community. Therefore, he has a presumptive right to bear arms. By infringing on that right, 922G3 contradicts the plain text of the Second Amendment. True, Heller described the Second Amendment as applying to law-abiding responsible citizens, and Bruin used the phrase law-abiding 14 times, including in the opening sentence, where it says that the Second Amendment protects the right of ordinary law-abiding citizens to possess a handgun. The government seizes on that language and insists that the Second Amendment does not extend to Daniels because he is a criminal. But we cannot read too much into the Supreme Court's chosen epithet. More than just model citizens enjoy the right to bear arms. Indeed, in the United States v. Rahimi case from the Fifth Circuit in 2023, Rahimi held that citizens accused of domestic violence still had Second Amendment rights. It reasoned that when Heller and Bruin used the phrase law-abiding, it was just shorthand to exclude from the discussion the mentally ill and felons, people who were historically stripped of their Second Amendment rights. So, originalist constitutional argument, only at the beginning of the United States, 1776, 1789, only felons and mentally ill were stripped of their Second Amendment rights. So that's your nation's tradition of firearms regulation. That's what they're going to be leaning on a lot here. Because Daniels is not a felon or mentally ill, Rahimi's treatment of the law-abiding moniker suggests that he has presumptive Second Amendment rights as well. And the level of mental illness we're talking about is not like you go see a therapist once in a while or whatever. We're talking about like people who have been diagnosed like mentally incapable. Still, Heller's and Bruin's emphasis on law-abiding citizens hints that Congress and state legislatures have greater latitude to limit the gun liberties of the lawless. But as a general rule, limitations on the Second Amendment come from the traditionally understood restrictions on the right to bear arms, not because ordinary citizens are categorically excluded from the privilege. Once we conclude that Daniels has presumptive Second Amendment rights, the focus shifts to step 2 of the Bruin analysis, whether history and tradition support 922G3. So now this is the history and tradition analysis. Before we decide, we must ask a methodological question. What kind of similarity are we looking for? Okay, so is 922G3 consistent with our tradition of gun regulation? We must look for similarity. What kind of similarity are we looking for? I do not like this line of logic, but it's what we're doing. That depends on whether 922G3 addresses a general societal problem that has persisted since the 18th century. This is the test. Does the gun restriction address a general societal problem that has persisted since the 18th century, or an unprecedented societal concern that the founding generation did not experience? So these are two different categories, 1 and 2. Bruin does not require more than relevant similarity here. Relevancy would be making something more likely to be true or less likely to be true. So if it bears on the truth or falsity of the thing, then it's relevant. It is true that the founding generation was familiar with intoxication via alcohol and was familiar with marijuana plants. But the founders grew hemp to make rope. They were not familiar with widespread use of marijuana as a narcotic, nor the modern drug trade. And they have some citations here. Richard J. Bonney, Charles H. Whitebread II, The Forbidden Fruit and the Tree of Knowledge, an Inquiry into the Legal History of American Marijuana Production. Thus, though intoxication generally was a persistent social problem, the founding generation had no occasion to consider the relationship between firearms and intoxication via cannabis. Although marijuana might be comparable in some ways to alcohol or tobacco, merely by making the comparison, we have moved past the hunt for a distinctly similar law and are engaged in analogical reasoning. Indeed, Bruin's discussion of the distinct and relevant similarity seems aimed at interpreting historical silence. That is, when the historical record reveals no regulations of a particular kind, we could interpret that silence in one of two ways. We could say that it means nothing, or we could count silence as evidence that the public did not approve of such a regulation. Bruin says we should make the latter inference, at least when the public experienced the harm the modern-day regulation attempts to address. By contrast, when the ratifying public did not confront a particular harm, its failure to regulate says little about whether it approved such a regulation. In that case, we look instead for analogs, similar harms that the founding generation did confront and the regulations they used to address them. So intoxication via alcohol versus intoxication via tobacco versus intoxication via marijuana. What would it be like if they had intoxicating marijuana back then? How would they regulate it? That's what we're trying to do, is get in the heads of the founding fathers and decide what they would have done, because that's how we get around basic gun regulations. Just as founding-era prohibitions on firearms in sensitive places can extend to new and analogous sensitive places, we can compare the founders' treatment of one problem to new problems that the founders could not have anticipated. Even so, the government has the burden to find and explicate the historical sources that support the constitutionality of 922G3. Here, the government's proffered analogs fall into three general buckets. 1. Statutes disarming intoxicated individuals. 2. Statutes disarming the mentally ill or insane. And 3. Statutes disarming those adjudged dangerous or disloyal. Each deserves independent consideration. 1. Because there was little regulation of drugs until the late 19th century, that's the 1800s, intoxication via alcohol is the next closest comparator. Throughout the colonial period and into the 19th century, Americans drank alcohol, and lots of it. Common sense indicates that individuals who are impaired by alcohol lack the self-restraint to handle deadly weapons safely. I concur. So it is unsurprising to find historical laws dealing with guns and alcohol. Such rules are relevant to our history and tradition of gun regulation. Unfortunately for the government as a party, that regulatory tradition is sparse and limited during the relevant time period. Despite the prevalence of alcohol and alcohol abuse, neither the government nor the amici curiae, the Friends of the Court briefs, identify any restrictions at the founding that approximate 922G3. Although a few states after the Civil War prohibited carrying weapons while under the influence, none barred gun possession by regular drinkers. Founding-era statutes concerning guns and alcohol were few. They were also limited in scope and duration. The laws that did exist had two primary concerns. 1, the misuse of weapons while intoxicated, and 2, the discipline of state militias. Consider the first group of statutes. In 1656, Virginia banned shooting any guns at drinking. But in historical context, that was not a disarming regulation. Virginia was a brand new colony at the time. The 1656 statute was explicitly passed to conserve gunpowder, which was at a premium, and because ill-timed gunshots might be mistaken for a signal that local Indians were attacking. Not only was the statute enacted for a different purpose, but it did not even ban gun possession or carry. It only prevented the colonists from misusing the guns they did have during bouts of drinking. Another law passed in New York in 1771 prohibited citizens from firing guns from December 31st to January 2nd because of the great damage done by those intoxicated with liquor during the New Year's celebrations. The statute had a similar purpose as 922G3 does, preventing public harm by individuals under the influence. Nevertheless, the law was strikingly narrow. It applied on only 3 days out of the year, it only prevented firing guns, not possessing them, and it applied only to those under the influence, not habitual drinkers. Beyond that duet of colonial regulations separated by over a century, the government identifies no founding-era law or practice of disarming ordinary citizens for drunkenness, even if that intoxication was routine. Instead, the government points to a second group of statutes regulating militia service. For example, a soldier could be disarmed if he showed up for militia service in New Jersey, disguised in liquor. Pennsylvania did the same in 1780. For related reasons, dram shops were prohibited from selling to local soldiers. Those laws, however, are even less probative. For one thing, their purpose is different. They exist to ensure a competent military. A service member cannot perform his duties if he is impaired. Furthermore, the limitations applied only to the militia. None of the laws spoke to the ability of militiamen to carry outside of their military service. At the founding, as today, restrictions on the liberties of servicemen tell us little about the limits acceptable for the general public. Given the prevalence of drinking at the founding, that handful of laws puts the government on shaky footing. The government has failed to identify any relevant tradition at the founding of disarming ordinary citizens who consumed alcohol. The government's Reconstruction-era Civil War, post-Civil War evidence, though stronger, still falls short. Between 1868 and 1883, 3 states prohibited carrying firearms while intoxicated: Kansas, Missouri, and Wisconsin. Missouri's law was challenged under the state constitution, but was upheld by the Missouri Supreme Court. The opinion acknowledged that the state constitution secured to the citizen the right to bear arms in the defense of his home, person, and property, but the court reasoned that if the state could regulate the manner in which arms may be borne, there is no good reason why the legislature may not do the same thing with reference to the condition of the person who carries such weapons. The ban on intoxicated carry was therefore in perfect harmony with the Constitution. Those laws come closer to supporting 922G3, but they are notably few. The Bruin Court doubted that 3 colonial-era laws could suffice to show a tradition, let alone 3 laws passed 80 to 90 years after the Second Amendment was ratified. More fatally, 922G3 is substantially broader than the post-bellum intoxication laws. On Bruin's 2 axes of relevant similarity, the postbellum laws and 922G3 share a common why, preventing public harm by individuals who lack self-control and carry deadly weapons. But the how is different. At most, the postbellum statutes support the banning of the carry of firearms while under the influence. But Section 922G3 bans all possession, and it does so for an undefined set of users, even if they are not under the influence. As applied to Daniels, then, 922G3 is a significantly greater restriction on his rights than were any of the 19th century laws. Although the older laws' bans on carry are likely analogous to 922G3's ban on possession, there is a considerable difference between someone who is actively intoxicated and someone who is an unlawful user under the law. But the statutory term unlawful user captures regular users of marijuana, but its temporal nexus is vague. It does not specify how recently an individual must use drugs to qualify for the prohibition. According to the implementing rules, a person may be an unlawful current user of a controlled substance, even though the substance is not being used at the precise time the person possesses a firearm. An inference of current use can be drawn from a conviction for use or possession of a controlled substance within the past year. So you are an unlawful or habitual user if you have been convicted within the past year. That's like the least intrusive one, and it gets more, they can infer further from that. Daniels himself admitted to smoking marijuana 14 days a month, but we do not know how much he used at those times, and the government presented no evidence that Daniels was intoxicated at the time he was found with a gun. Indeed, under the government's reasoning, Congress could ban gun possession by anyone who has multiple alcoholic drinks a week from possessing guns based on the postbellum intoxicated carry laws. The analogical reasoning Bruin prescribed cannot stretch that far. A further problem with the Reconstruction-era statutes is precisely that they emerged during and after the Reconstruction. Bruen did not discount the relevance of late 19th century history, but it insisted that the Second Amendment's meaning is fixed according to the understandings of those who ratify it. A tradition cannot inform the original meaning of the Bill of Rights if it emerges 100 years later. When 19th century practice is inconsistent with the categorical protection of the Second Amendment, the text controls. Admittedly, there is an ongoing scholarly debate about whether the right to bear arms acquired new meaning in 1868 when it was incorporated against the states. This is that weird legal operation where the Bill of Rights, the first 10 amendments, didn't apply to the states for a while, and then in 1968, which I'm guessing is when the 14th Amendment was ratified. I don't know my 14th Amendment history, but that is the amendment that then made the Bill of Rights applicable to the states. So you get a lot more federal government regulation and involvement in the states, and a lot more court intervention in cases like this, but back then, because now the federal law applies, or equal protection of the laws and such. So state laws can now be challenged a lot more easily. You start to get civil rights laws and things at this time. But the instant case involves a federal statute and therefore implicates the Second Amendment and not the 14th. So we're not dealing with a state law. Even if the public understanding of the right to bear arms did evolve, it could not change the original meaning of the Second Amendment, which was fixed when it first applied to the federal government in 1791. So I was close. I said 1789. It's 1791. And even if late century practice sheds some dim light on founding era understandings, the most the Reconstruction era regulations support is a ban on gun possession while an individual is presently under the influence. By regulating citizens like Daniels based on a pattern of drug usage, 922G3 goes further, and our history and tradition do not support that leap. As an alternative, the government posits that the tradition of disarming the mentally ill supports the law. To quote Heller's now famous caveat, long-standing prohibitions on the possession of firearms by the mentally ill are still presumptively lawful. Obviously, mental illness and drug use are not the same thing. But there is an intuitive similarity. Those who are briefly mentally infirmed as a result of intoxication are similar to those who are permanently mentally infirmed because of their illness or disability. We note at the outset that there is not a clear set of positive law statutes concerning mental illness and firearms. In fact, the federal ban on gun possession by those judged mentally ill was enacted in 1968, the same year as 922G3. But scholars have suggested that the tradition was implicit at the founding, because in 18th century America, justices of the peace were authorized to lock up lunatics who were dangerous to be permitted to go abroad. In other words, the greater restriction included the lesser. If the insane could be wholly deprived of their liberty and property, the government could necessarily take away their firearms. Of course, the practice of institutionalizing so-called lunatics does not give clear guidance about which lesser impairments are serious enough to warrant the loss of constitutional freedoms. But we can assume that intoxication with marijuana is analogous to short-term mental illness. We can assume that intoxication with marijuana is analogous to short-term mental illness. I will just let that sit with you for a moment. That's pretty freaking good. Which judge wrote this? Judge Smith. That is a quote that is going on the wall behind me. Before Judge Jerry E. Smith, we can assume that marijuana intoxication is similar to short-term mental illness. Nice. Dr. Benjamin Rush, who signed the Declaration of Independence, said a temporary fit of madness was a symptom of drunkenness. And in an influential treatise on constitutional law, Thomas Cooley described drunkenness as a form of temporary insanity. The same could be said of intoxication via marijuana. Still, that comparison could justify disarming a citizen only while he is in a state comparable to lunacy. Just as there was no historical justification for disarming a citizen of sound mind, there is no tradition that supports disarming a sober citizen who is not currently under an impairing influence. Indeed, it is helpful to compare the tradition surrounding the insane and the tradition surrounding the intoxicated side by side. The founders purportedly institutionalized the insane and stripped them of their guns, but they allowed alcoholics to possess firearms while sober. We must ask, in Bruin-style analogical reasoning, which is Daniels more like, a categorically insane person or a repeat alcohol user? Given his periodic marijuana usage, Daniels is firmly in the latter camp. If and when Daniels uses marijuana, he may be comparable to a mentally ill individual whom the founders would have disarmed. But while sober, he is like the repeat alcohol user in between periods of drunkenness. In short, neither the restrictions on the mentally ill nor the regulatory tradition surrounding intoxication can justify Daniels' conviction. Perhaps the government could show that the drugs Daniels used were so powerful that anyone who uses them is permanently impaired in a way that is comparable to ongoing mental illness. Or the government could demonstrate that Daniels' drug use was so regular and so heavy that he was continually impaired. Here it has shown evidence of neither. Finally, the government asserts that Congress can limit gun possession by those dangerous to public safety. Okay, so we had intoxication, we had mental illness, and now we're going to get to part 3, dangerous people. The government contends the principle was well understood when the Second Amendment was ratified, and it posits that Daniels, a repeat marijuana user, was presumptively dangerous enough to be disarmed. Although there is some historical evidence for the government's underlying principle, the historical examples of danger-based disarmament do not justify the modern law's application here. As Justice Barrett detailed when she was a judge on the Seventh Circuit, history supports the intuitive proposition that the government can keep deadly firearms away from dangerous people. Even the amici, who believe that Daniels should prevail on his Second Amendment challenge, suggest that the government can disarm the dangerous even under Bruin's history and tradition test. That said, no one piece of historical evidence suggests that when the founders ratified the Second Amendment, they authorized Congress to disarm anyone it seemed dangerous. Instead, the government collects different statutes disarming discrete classes of persons at various points in history. Those laws suggest an abstract belief that an individual's right to bear arms could be curtailed if he was legitimately dangerous to the public. The government's examples fall into two general buckets. First, states barred political dissidents from owning guns during periods of conflict. Many American states, for example, disarmed those who failed to take an oath of allegiance during the Revolutionary War. Second, both British and American governments disarmed religious minorities, especially Catholics. Each of those laws was generally based on concerns for the safety of the polity, but each disarmament also had its own unique political or social motivations. Almost all the laws disarming dissidents were passed during wartime or periods of unprecedented political turmoil. Indeed, founding-era governments did not disarm loyalists because they were thought to lack self-control. It was because both were viewed as potential threats to the integrity of the state. The same was true of religious minorities. The perceived threat was as much political as it was religious. Independent of those class-based restrictions, the government relies heavily on the Militia Act of 1662, which allowed the Crown to disarm those whom he judged dangerous to the peace of the kingdom. That is the most direct support for the government's principle that the legislature could prophylactically disarm any citizen who could potentially be dangerous. But Rahimi held that the Militia Act was not incorporated into American law. After all, the act was the justification for the widespread disarming of political opponents by Charles II and James II. After the Glorious Revolution, the 1689 English Bill of Rights expanded the right to bear arms in order to curtail the Militia Act's reach and limit the Crown's politically motivated disarmaments. Our Second Amendment is a direct descendant of that latter guarantee. If anything, our constitutional right to bear arms was purposefully broader than its English ancestor. Although some historians maintain that the Militia Act was still frequently used after the Glorious Revolution, its limitations likely did not survive the categorical command of the Second Amendment. Finally, the government posits that Congress can disarm dangerous citizens because the idea was discussed during the ratification of the Constitution. Sam Adams, for example, proposed an amendment at the Massachusetts ratifying convention that would have limited the right to bear arms to peaceable citizens. At the Pennsylvania ratification, the dissenting minority suggested several constitutional amendments, including one that would have protected the right to bear arms unless for crimes committed or real danger of public injury from individuals. And Heller in 2008 described the Pennsylvania proposal as an influential precursor to our Second Amendment, as many of the Pennsylvania minority's suggestions ended up in our current Bill of Rights. Again, however, we must pause. The predecessors of the Second Amendment gave concrete language to possible limits on the right to bear arms, yet that language was not adopted. Instead, the people ratified the unqualified directive shall not be infringed. Usually, when the relevant lawmaking body does not adopt language in a draft, we presume that the stricken language was not intended. Rahimi also considered those Second Amendment precursors and concluded that the unadopted language could not supplant the amendment's enacted text. That said, there is an undeniable through line in all those historical sources. Founding-era governments took guns away from persons perceived to be dangerous. Even if the disarming of loyalists and Catholics was limited to exigent historical contexts, no party identifies disputes regarding the lawfulness of such prohibitions at the time. Indeed, some states, such as Pennsylvania, disarmed dissident citizens while their state constitutions guaranteed a right to bear arms. And even if the founders repudiated the Militia Act and rejected the Second Amendment precursors, the language of those documents says something about the outer limit of the right to bear arms in the English tradition. Perhaps the Second Amendment was meant to do away with all those restrictions on liberty, and we can chalk such restrictions up to reactionary excess during the birth of a nation. On the other hand, we cannot completely discount the sheer number of disarming statutes at the time of the founding. Together, they suggest a public understanding that when a class of individuals was thought to pose a grave danger to public peace, it could be disarmed. Assuming the Second Amendment encodes some government power to disarm the dangerous, the question becomes, at what level of generality may we implement that principle? Bruin requires us to interrogate the historical record for relevantly similar regulations, but it does not allow us to enforce unenacted policy goals lurking behind the Second Amendment. Indeed, any ability to implement a dangerous principle is fenced in by at least two strictures in the applicable case law. On the one hand, the legislature cannot have unchecked power to designate a group of persons as dangerous and then disarm them. Congress could claim that immigrants, the indigent, or the politically unpopular were presumptively dangerous and eliminate their Second Amendment rights without judicial review. That would have no true limiting principle and would render the Second Amendment a dead letter. On the other hand, we cannot inspect a legislature's judgment of dangerousness using traditional standards of scrutiny. Bruin forbids us from balancing a law's justifications against the burden it places on rights holders. Imagine, for example, that a state legislature disarms all men, citing statistics that men commit more violent crimes than women. Before Bruin, we would have considered whether the evidence supporting male dangerousness was substantial enough and whether the law was sufficiently tailored to justify such a categorical restriction on gun rights. But Bruin forswears that kind of review. Similarly, imagine that the government bars all convicted cybercriminals from owning guns, referencing the dangerousness of cybercrime. Cybercrime is assuredly dangerous, but in a different way than is violent crime. Applying a standard of scrutiny, we might have interrogated whether Congress had adequately demonstrated that someone who spreads ransomware or pirates television shows is likely to be dangerous with a firearm. Again, Bruin heads that analysis off at the pass. How then do we square the post-Bruin circle? To remain faithful to Bruin, the solution is to analogize to particular regulatory traditions instead of general notions of dangerousness. The government must show that a historical danger-based disarmament is analogous to the challenged regulation. We must use Bruin's why and how analysis to assess whether the founding era restriction is relevantly similar to the modern one. We must ask, why was the group considered dangerous? Why does the modern law classify a person as presumptively dangerous? Is the comparison supported by the record? Etc. Can you guess what he's going to do? He's going to say that it only applies to intoxicated persons. Applying Bruin's framework, it follows that the government's theory of danger-based disarmament falls apart. Marijuana users are not a class of political traitors like British loyalists, nor are they like Catholics and other religious dissenters who were seen as potential insurrectionists. Daniels is not like the minorities who the founders thought threatened violent revolt. The government suggests that marijuana users do threaten the public peace. But at the time of the founding, that notion referred specifically to violence or rebellion, not generalized public harm. Furthermore, even as the founders were disarming Catholics, they left ordinary drunkards unregulated. The government has no meaningful response to the fact that neither Congress nor the states disarmed alcoholics, the group most closely analogous to marijuana users in the 18th and 19th centuries. As with the government's analogy to mental illness, we must ask, which are marijuana users more like? British loyalists during the Revolution or repeat alcohol users? The answer is surely the latter. The government asks us to set aside the particulars of the historical record and defer to Congress's modern-day judgment, but that is the kind of toothless, rational basis review that Broone proscribes. Absent a comparable regulatory tradition in the 18th or 19th century, 922 G3 fails constitutional muster under the Second Amendment. Daniels' conviction is therefore inconsistent with our history and tradition of gun regulation. We conclude only by emphasizing the narrowness of that holding. We do not invalidate the statute in all its applications, but importantly, only as it's been applied to Daniels. Nor do we suggest that a robust Second Amendment is incompatible with other reasonable gun regulations. Such statutes just need to be consonant with the limits the founding generation understood to be permissible when they ratified the Second Amendment. The government has failed to demonstrate that here, reversed, and it doesn't need to be remanded because the decision doesn't need to be entered. It just, this conviction needs to be overturned. So yeah, that does not mean that you should just go smoke a doobie and walk around with your gun. That's probably still prohibited. And you can maybe beat the time if you are in Daniel's position and your circuit, your appeals circuit agrees with you. But do you want to be that test case? So the good news is that if this Fifth Circuit decision is upheld by the Supreme Court, or maybe certiorari is denied, or maybe it's not appealed, and that means on some level your criminal defense attorney can argue that you're not in violation of the law simply for being a marijuana user. But, and I'm being very careful here, this is not individualized legal advice. That doesn't necessarily get you around any laws that or any prohibition on lying on federal firearms forms and such. All that needs to be still worked out. So until some official source tells you that marijuana use is not a prohibition for federal or for firearms possession, federally speaking, I wouldn't count on it. I would continue to behave the way everyone's behaved, whatever that is, and avoid admitting, like Daniels did. Like, okay, so he was Mirandized. They literally said you have the right to remain silent, and he did not remain silent. So I'm not sure. Maybe that caused the government to make the mistake of prosecuting the way that they did with insufficient evidence, or maybe he would just made a dumb move and said something he shouldn't have said. But the generalized advice is don't talk to the police until you've had a chance to talk to your attorney. And let your attorney guide you, and then you can choose whether you listen to your attorney or not, but it's going to be between you and them and not between some guy on the internet. Even if I am licensed, even if I have a 5-star rating, even if I have no disciplinary history, because even if I have a clean disciplinary history, that doesn't mean that I know how it's going to work out for you. So don't go doing stuff, but just keep an eye on it. Let me know what you think in the comments below.